Hi, my name is Mario Portugal. I'm a licensed attorney here in California, and today I'd like to talk about wills and trusts. Those are two important documents, and I've been having a few questions regarding how they work and how they are different one to another. So that's what we're going to be discussing today. So, as I mentioned before, we're going to be discussing the topic of wills and trusts and what they are important and how different they are one to each other. So, basically, if you like to make an estate planning, meaning if you want to create an instrument to protect your assets and also how they're going to be distributed between your heirs, you might like to have a estate planning document like a trust, especially if you like to have some control over it during life. There is an inter vivos trust, meaning that you can have an administrator or trustee who actually manage the property or the assets on the beneficiary. The beneficiary in life, it could be the trustor or the person that owns the assets or properties during life. And once they create the trust, basically they transfer those assets and property to the trust, and it's a separate entity, and they have their own taxation, and that's one way to protect your assets from your personal liabilities. If you have a business or you have a lot of debt and you want to protect some assets, and it's not just for the purpose of trying to avoid creditors, then there's a valid purpose. The only thing that you cannot protect from collectors in a trust are debts to the government, child support, and also taxes. If you have taxes to the IRS, they can pierce the trust and actually collect the money from the trust. So during life, you may want to have a beneficiary of yourself. That way you protect your assets. And it's very common people with residential properties to put the property in a trust, especially if they are elder, because I understand that the Social Security benefits got some restrictions depending on your income and your assets. So if you got multiple properties and you have multiple properties that you're receiving rents from, one way to avoid Social Security and losing some benefits is put them on a trust and have yourself as a beneficiary or naming a third-party beneficiary so they can collect and also have somebody else to manage those assets for you. And then there is a portion of the trust that might work as a will, meaning that once you pass away, you can also determine how those assets are going to be transferred to your heirs. If those assets are personal property, you can transfer to anyone the way you like, as long as you follow certain formalities and formulas. But then if those assets are actually community property, there are some limitations, some rules you have to follow. Community property got a portion that might become personal property eventually, and that is freely transferable. But then there is some portion that is mandatory to go to the heirs. You cannot transfer those. So in those cases, it's very important that you actually talk to an attorney and make sure that you are in compliance. The difference between the trust and the will is that the will basically operates at death. Once somebody passes away, then they can transfer the property via will, avoiding probate. Same way as at the trust, but the trust got the benefit that you can actually manage assets during life. So the importance of these instruments are like during life, you might have to actually the capacity to manage those assets and also make arrangements on how they're going to be transferred. But then, I mean, if something goes wrong and then if you got an issue and you lose capacity, then basically your heirs or your family might be forced to go to probate, meaning they have to go to court to actually either be named as a as the person who manage your assets, or to actually get the assets transferred to you if you already pass away. So that's a really important benefit from these two instruments. Another important benefit is taxation. Some people goes like, oh, how about if you want to transfer these assets to my heirs, and rather than doing via will or trust, I just make a regular transfer. Well, a regular transfer is taxed, meaning the person that you transfer is basically a buyer, and then they might have to pay income taxes on those assets. And then depending on the transaction, there might be some issues. If you transfer via will or trust, and there is no exchange of money needed, and there is also no income tax, so meaning that they take in the stapling basis. So those are two of the main keys or benefits to doing a living trust or a will, that you avoid probate court. Some cases, if you don't have a mandatory heir, then the asset might go back to the government. So if you don't want to do that, there is a lot of people that they don't have children or mandatory heirs, and in those cases they decide to donate their assets to a non-profit or maybe to a hospital for research. So you can do that either via living trust with the component of passing the assets at death, or via will. You can name the beneficiaries, and in those cases, especially in the will, if you actually make a will to benefit the public, there is flexibility on the terms of the will, meaning that even if the institution that you like to transfer your assets disappears, meaning let's say you name Hospital X as the beneficiary of your will, and Hospital X closes, then as long as the intent is to benefit some type of research or some charitable institution, that might go to a similar institution, meaning Hospital Y, if they have similar purposes, they might benefit and claim those assets for the benefit of the public following your intent. So those are one of the main components. So if you like to either make an estate planning via living trust or a will, it's very important that you check with an attorney. There are some local attorneys that they don't charge for consultation, so you might like to take advantage of that. And then make sure, especially if you're elder, that your assets are in order. So once there is any event that might cloud your capacity or a death, so your beneficiaries got some assets to cover for your expenses and also to benefit themselves. So make sure that you understand both difference. If you have a consultation, make sure that they give you your options, and then that you actually discuss it with your family, and then you guys make a plan. Because especially when somebody is elder and got some assets, it's a good practice to have either of these two instruments, especially a trust, because that way if you got an illness, you actually got some assets that your heirs or a trustee can manage for the benefit of your treatment, as well as you're placing your affairs in order in case there is the event of death. So make sure you discuss this with an attorney, and if you like me to give you a consultation, I'm gonna leave my information in the description box, and also I'm gonna leave it at the end of this video. Thank you for listening, and we'll see each other next time. Bye.